Good morning and welcome. Thank you for joining us for our virtual in-house counsel seminar. This is our second session of the day titled Pell Mell Rapid Fire Legal Update. I'm Jen Ritter-Tmassick, Marketing Coordinator of Events and Proposals at Warden Smith, and I'll be your MC for this session. If you have any issues with video or sound quality during the presentation, please reach out via the Zoom chat feature and I'll try to troubleshoot with you. Additionally, if time allows, our speakers will take live questions from the audience at the end of the session. If you have a question at any time, please type your question in the Q&A box. During a portion of this session, you will have the opportunity to answer a few questions via our polling software. Please note, if you attended our first session and participated in those polling questions, you do not have to opt in again. If you did not attend the first session, opting in to participate is easy. Take out your mobile phone and text the message WS webinar to the number 22333. So you'll open a new text message in the phone number area. You'll type in the number 22333, and in the message area, you'll type in WS webinar, hit send, and you should get a confirmation that you are now able to participate. Today's rapid fire legal update speakers are Richard Crowe, Chris Edwards, Jamie Norman, and Haley Wells. Richard has significant experience in a broad range of business law matters, including mergers and acquisitions, tax planning, private securities offerings, and startup businesses. He recently served as in-house counsel for a major background screening and compliance provider, giving him the rare experience of managing both the inside and outside counsels for the same entity. Chris is a dynamic appellate attorney and civil litigator whose multifaceted practice focuses on complex legal issues related to business, intellectual property, and appellate matters. As a civil litigator, Chris has handled all aspects of commercial disputes involving contracts, non-compete clauses, trademarks, copyrights, and patents. Jamie works regularly with individuals, corporations, and governmental entities on a variety of complex legal matters. His experience in substantive areas of the law includes government contracts, government relations and lobbying, and economic development law. Haley regularly advises individual and corporate clients in matters of covenants not to compete, employment discrimination, discipline and termination, harassment, wrongful discharge, wage and hour issues, personnel policies and procedures, and preparation of employee handbooks and employee agreements. Again, thanks for joining us. Richard, let's kick off our rapid fire.
Thanks, Jen. Welcome back, everyone. I think many of you are aware of the passage of the Infrastructure Investment and Jobs Act, signed into law on November 15th. And you're also probably aware that there's a Build Back Better Act being kicked around Congress at the moment. It's passed by the House on November 19th, and it's now in the hands of the Senate. I want to give you a quick rundown on some of the tax provisions contained in both the Infrastructure Act and the House version of the Build Back Better Act. And just to be clear, the Senate has not taken that act up for vote yet. There's some anticipation that might be a mid-December vote, but who knows at this point. But the Infrastructure Act was signed into law by President Biden on the 15th of November. There are very few tax provisions contained in that act, so there's not a lot to update you from a tax perspective. However, one that stood out as important to businesses is the early termination of the employee retention tax credit. That tax credit has been a lifeline to businesses during 2020 and 2021 who might have suffered a full or partial suspension of their operations due to a governmental order related to limitation on commerce or travel or group meetings because of COVID-19. And under some prior acts, that employee tax retention credit was available throughout all of 2021. So employers who paid qualified wages all the way through December 31st, 2021, previously were eligible for an employee retention tax credit if they otherwise qualified, had a partial or full suspension of operations during that period. However, the Infrastructure Act has ended that tax credit early. So qualified wages will no longer qualify you for that credit after September 30th. So we're going to lose a quarter of that employee retention tax credit. That is really the only tax provision in the Infrastructure Act that I thought was worth mentioning during this seminar. There are a couple of others, but they're a little outside of the realm of this seminar. On to the Build Back Better Act. That the House passed its version of the bill on November 19th, and the legislation is now in the hands of the Senate, where it's anyone's guess on what happens next. At the time we started planning this seminar, we expected the act to have been passed by the Senate, possibly signed into law by the president. However, I'm sure you've watched the news. The negotiations over that bill stalled, and it remains unclear exactly what tax and other provisions are ultimately going to be contained in the final act, or if there will be a final act signed into law at all. However, there are some indications that the Senate will take the act up for a vote in mid-December, just difficult to tell with certainty. So I thought it would be interesting to start with a quick rundown of some of the tax provisions that we thought might be included in that act, but did not actually be included in the version the House passed. So some of these provisions are the ones that you've heard about for the past 11 months. Some caused some concern and consternation for business owners and companies alike. But these are things that did not end up in the House bill. Now, again, there's no guarantee that they don't get picked back up and included in some form in the Senate version of the bill. But I would think it'd be a little unlikely. So the House version of the Build Back Better Act did not contain any individual income tax rate increases. It did not contain the long-term capital gains rate increases or an increase to the qualified dividend rates. Those issues were on the table for a number of months and concerned quite a few business owners. The bill also did not reduce or eliminate the qualified business income tax deduction. That's the deduction for a percentage of qualified business income from a business that's operated as a sole proprietorship or through a partnership or S corporation. That was a deduction that was enacted in the Tax Cuts and Jobs Act. And it's already set to expire, I believe, at the end of 2025. However, there was some talk about ending that early or reducing the benefits. That did not happen in the most recent House bill. There was no change to the general corporate tax rate. However, I will mention later that there's some included in the House bill a minimum tax for certain large corporations. But otherwise, the general corporate tax rate in effect today did not change. The bill does not permit certain older C corporations to convert to partnerships on a tax-free basis. That was sort of an odd provision that was thrown in by the Ways and Means Committee at one point as a possible candidate for inclusion in the bill. And it would have allowed S corporations that were S corps at all times since May 13th of 1996 to convert tax-free to a partnership if they did it within the next 2 years. There's obvious benefits to being permitted to do that. Under current law, if you are to convert a S corporation to a partnership, that's a taxable event. And so it stalls many of those conversions. That provision did not make it into the House bill. There are no modifications to the rules applicable to carried interests. These are the interests that you hear about. Some of you might have received. They're profits interests received by fund managers or real estate development sponsors and others that are taxed at long-term capital gains rates if certain conditions are met. Congress has previously enacted some limitations and some rules that apply to carried interests. It's Internal Revenue Code 1060, but there was some conversation about either maybe adding some additional restrictions on those, maybe extending the time period during which you had to own your carried interest in order to benefit from long-term capital gains rates if the interest was sold. But those conditions were not contained in the House bill. The bill also does not reduce the lifetime estate and gift tax exemption amount, which was of concern. Now I want to move on to some of the provisions that are included in the House version of the Build Back Better Act. And it's again unclear what the Senate's going to do with these, but these are things that right now are under consideration and the House voted and approved on. The SALT, the state and local tax cap that you might have heard about, which was previously set at $10,000 per individual under the Tax Cuts and Jobs Act, would be increased to $80,000 under the most recent House bill. That's the, one interesting aspect of the SALT tax cap, a corporation that pays state income tax and other state and local taxes is not subject to that cap on deducting those state and local taxes that are paid. So if you have a C corporation that's paying its own state tax or real estate taxes, it's going to be able to deduct those taxes in full. That doesn't apply to individuals, however. They do get hit with this cap under current law, and that includes owners of pass-through entities. So to the extent they pay their own state income taxes, they pay the real estate taxes, other personal property taxes, the deduction for those are capped at $10,000 under current law. So an increase to $80,000 would benefit these business owners, and it's particularly important in a state like North Carolina, where it appears that our legislature has stalled in its attempt to pass a SALT cap workaround that's been passed by a number of other states. That workaround essentially would have permitted a pass-through entity to directly pay state income taxes to the state, and then of course allowing that corporation to deduct that amount in full. That hasn't been passed by North Carolina yet. So if this House version of the SALT cap gets passed, that actually might benefit some North Carolina residents. The minimum corporate tax rate, the act would impose a minimum 15% corporate tax rate on certain large corporations. These are corporations other than S corporations and regulated investment companies that have average annual net income for any 3-year period over $1 billion. So if that's the case for that corporation, then it's going to be subject to a 15% tax of its net income. Now, the interesting part about the House bill, when it refers to average annual net income, it's actually referring to adjusted financial statement income, not taxable income. So this is going to be essentially a tax imposed on the profits shown by a corporation on its financial statements, which is an interesting way to address the issue. You've also have included in this act a surcharge on stock buybacks. The act would impose a tax of 1% on the fair market value of stock of a domestic publicly traded corporation that is repurchased by the corporation. Right now, the proposal is that would be effective for repurchases after December 31st, 2021. The bill would include a new limitation on the amount of net interest expense of certain domestic corporations that may be deducted. Interesting enough for business owners and startup owners, the bill would also amend Section 1202 of the code, which is the section that allows for an exclusion of gain from the sale of qualified small business stock, to disallow the 75% and the 100% exclusion of gains. In essence, leaving if it's a taxpayer that has adjusted gross income greater than $400,000. So the net effect of that is, as opposed to the current law where a taxpayer could exclude up to 100% of the gain from the sale of qualified small business stock, this bill is going to do away with that, leaving 50% of that gain as what can be excluded if the taxpayer has adjusted gross income greater than $400,000. The House bill also expands the 3.8% net investment income tax. That net investment income tax does not apply to flow through income from an S corporation or partnership today if the taxpayer individual is actively involved in the business. However, the House bill will apply that 3.8% net investment income tax to income even flowing from S corporations and partnership entities, even if the taxpayer is actively involved in that business, if the taxable income for that taxpayer is over $400,000. That seems to be their magic numbers, $400,000 of income or more. Some of these acts are going to apply to you to increase your tax liability. We also have the interesting component. It's sort of a carryover from some initial conversations the House Ways and Means Committee had. The bill does include a surcharge on high-income individuals, estates, and trusts. It's a surcharge that would equal 5% the amount of the taxpayer's adjusted gross income that exceeds $10 million, plus an additional 3% of the amount of adjustable gross income that exceeds $25 million. So those are not by any means all of the provisions. Those are the tax provisions that I thought might be most relevant to this audience. Again, it remains to be seen what the Senate does with that and whether or not they pick up some of the tax provisions that were excluded from the House bill or whether they modify some of the ones that were included That remains to be seen, and we might know a little more through the remainder of December. With that, I'm going to turn this over to my partner, Chris Edwards. Thank you.
Thanks very much, Richard. Good morning, everybody. My name is Chris Edwards, and I'm going to talk to you about electronic discovery. If you have ever managed outside counsel in a litigation matter, you know that discovery is a bear. It is disruptive to your organization. It is disruptive to your internal client because it requires a large time commitment. And that's not just taking depositions, it's also seeking out documents. And that's what we're going to talk about today. Everybody's least favorite part of discovery, document discovery. It is, I think, universally reviled, but it is also very important because that's where you get the foundation of your case. That's how you stake out the other side's theory and the other side's claims. As I mentioned before, document discovery, like all discovery, is expensive. And there are two primary sources of expense, I think. The first is actual financial cost to your organization. There's an expense in having an attorney review documents for production. There's also an expense in terms of lost opportunities and lost time when you have to go back to your internal client, ask for emails, ask for paper documents. And so we're going to talk about a way to streamline those processes and hopefully reduce the cost, both real and opportunity cost. So the first thing I want to talk about is the use of search terms in isolating potentially responsive documents. So again, traditional discovery requires you to go to your client and ask for documents, and that's easy in a lot of cases, but with the advent of email, with more emails being sent and being requested through document discovery, you really are looking now at a situation where you may be asked to search for documents that are 3, 4, 5 years old. I've got several cases now where documents as old as 15 years old, emails from 15 years ago, are relevant and are being searched through. And so, but that's not the entire process. You know, you're getting those documents from your client, and then you're turning them over to your attorney. Your attorney is then reviewing them, and the sheer number of documents. We do not empty out file cabinets anymore. Instead, we keep basically everything, and that elevates the expense. So, what can we do about that? And the first answer is encourage your outside counsel to employ search terms. It really is as simple as it sounds. The attorneys in a case, when they decide to utilize search terms, will draft a list of search terms that cover potentially relevant issues in the case. And then those searches are run against your email database, whether that's Outlook or Gmail or anything else. We can run those searches against your database and identify a world of potentially responsive documents for review. This is a great way to improve efficiency. From an efficiency standpoint, you are not going back and asking for documents, but you are instead having your attorney come into your system, or someone in your attorney's office come into your system and extract all of the potentially responsive documents, and that usually takes about a day. I mean, it is a great way to cut time, and you don't know that it's happening. There might be minor slowness in your system, but you're not really going to experience any sort of slowdown of the type you would if you were just going and looking for those documents yourself. What we do when we run those searches, we run them against custodians, which are all of the potentially responsive, all the individuals with potentially responsive information. And this is a really flexible process. It kind of depends on the complexity of your case. I'm involved in a case now where the case is very, very complex. And so to match that complexity, we've used more than 100 search terms to pull discrete documents into our database for review. I've got another case where we only used, I think, 15 or 20. It really does depend on the facts of any given case. And it's not applicable just to one type of case. It's not just commercial contract disputes. It's not just internal business disputes. This can be relevant in wage and hour disputes. This can be relevant in Fair Labor Standards Act, any type of litigation that you as an in-house counsel might have to manage. So again, this process is designed to enhance efficiency. Instead of going back to your client, you are just running a discrete set of terms against your email database, and then your attorney is exporting those from your internal database to their server for review. We can also do this functionality against cell phones where the searches are run against text messages, and the text messages can then be pulled and reviewed, because increasingly, people, particularly in small companies, are not using their email for everything. They are texting each other, and sometimes those documents can become relevant. So we've covered how to export the documents. I want to touch on next how we review the documents. The search terms are not designed to be precise. The goal is to create Boolean searches that are close, but that are actually over-inclusive, so that we're not leaving responsive or relevant or important information on the server. So that can create a very large pool of data. In the case that I mentioned with 100 search terms, it produced almost 200,000 documents. In the case that I mentioned with 20 search terms, those terms produced 2 million documents. Somebody has to review those, and that is a tremendous real expense when you figure that it might take an experienced attorney familiar with your case, at minimum, a minute to determine whether an email or some sort of correspondence is responsive to a request for production of documents. If you start talking in terms of hundreds of thousands of documents, those minutes add up very quickly to a large expense. That's all the more true when you realize that the first level of review is not necessarily the final level of review. There will be other attorneys who put their eyes on these documents. And so we can use electronic discovery, particularly the electronic discovery vendors that we use all have this capability, to use technology-assisted review, what some people call predictive coding. Instead of reviewing every single document in the database, using predictive coding, someone trains a set of documents. And the size of the set really depends on the number of issues in the case and the overall size of the potentially responsive document universe. I've trained data sets of 300 and 400 documents, and I've trained data sets of 3,000 and 4,000 documents. But you're reviewing those documents and trying to separate the wheat from the chaff and determine what is and what is not responsive within this limited universe. And then as you're doing that, you're training an algorithm. And the algorithm starts picking up on keywords, key phrases, key people, and key timeframes. And when it does that, once it is fully trained and stable, it can be run against the entire universe of potentially responsive documents. And that tells you, it gives you a score, a percentage likelihood that the document will be responsive to what the algorithm perceives to be an issue in your case. This can be a tremendous savings. You can review several hundred documents, and it can reduce your review data set by as much as 90%. So it's an investment in time up front to review just a few hundred documents or a few thousand documents. And then the algorithm says, well, all of these documents are potentially responsive. All of these documents are potentially responsive. We then set a confidence range of typically about 75%. So if a document has a 75% likelihood of being responsive, then that document will get reviewed. But if it is 74% or less, we don't review the document. And so that's cutting out a tremendous number of documents that actually need to be physically reviewed. This procedure, using this kind of means testing to determine whether a document, the threshold at which a document is responsive, and then reviewing above that threshold, has been approved by courts. It's been upheld as a reasonable way to approach document intensive discovery. And so it has resulted in a tremendous cost saving for some clients. The thing to keep in mind about technology assisted review or predictive coding is that the expense will vary based on the number of documents. It will vary based on the size of the database and based on the service used. I know, for example, we have a certain space threshold that we can use technology assisted review with a certain vendor for free for a month, but then above that it starts to cost, and there would be a monthly management fee. So it's one of those things that you're going to want to talk to your attorney about. People are demanding it though, because even with a monthly fee, the idea of taking, so for example, in this case with 2 million documents, we only ended up reviewing about 45,000 documents instead of 2 million through the use of predictive coding. And so again, if you're factoring in the basic assumption that an attorney is going to take a minute to review a document, cutting down the number of potentially responsive documents by more than 1.9 million is a substantial savings. So again, these are just two topics. They're being used increasingly more and more in electronic discovery. The first, search terms, just crafting Boolean searches to help you identify potentially relevant documents, and then the use of predictive coding against that universe of documents to help you identify which ones are responsive and need to be produced. And so those are important things for you to have in your arsenal the next time you have to manage outside litigation. And with that, I will turn this over to my partner, Jamie Norman. Thank you all very much.
Thank you, Chris. Appreciate that. We're going to spend some time this morning looking at an update to government relations in general, but especially lobbying and the law, what I call constant compliance for in-house counsel. That's something you're concerned about, and then constant change, whether that's the law behind the compliance or the policies that are being driven by the lobbying. We've got some polling. I'd like to get some ideas from you if you can answer. Does politics impact your company's bottom line? A yes, no, or I'm not sure. As you can imagine, of course, politics impacts every company's bottom line in some way or another. Some, though, are more directly impacted than others. You might be a company that is in a highly regulated industry where policy and decision makers have a direct impact on your ability to operate, or have an ability on your opportunity for growth. So we're seeing certainly a lot of yeses. Jen, you can go to the next one. Now, if politics does in fact impact your bottom line in some way, do you do anything about that? Do you have an in-house lobbyist, either in your legal department or in your marketing department, or do you have an outside contract lobbyist? And this is either in Raleigh at the state level or in Washington, D.C. at the federal level. See, about 3/4 of you do, and that's very consistent with a sophisticated company, especially a company that would have an in-house counsel often has specific policy needs out there that can be addressed directly through lobbying. So we'll go on to the next poll, Jim. One component here that we see a lot of in my practice is working with trade associations. So if you're a member of a trade association, does it have a lobbyist? And almost all trade associations have a lobbyist because that's one of their primary purposes, is to advocate for the trade, for the industry, for whatever that sector is. Jen, go on the next slide. In North Carolina and in Washington, D.C., lobbying law is essentially based on a disclosure system. It's a regime where if your company is lobbying a particular issue, you disclose who is doing the lobbying, how much they're getting paid, and what the issues are. And from the disclosure regime flows a whole series of behavioral compliance issues. What a lobbyist can and cannot do, what they can and cannot give to an elected official or to a senior staffer, for example, all flow out of the lobbying triggers. And we'll talk a little bit more about that in just a second. But before we do that, I want to reference you and give you a frame of reference for what the statutes are, where if you're in-house counsel and you're talking to outside counsel, or if you're looking at your marketing plan and you see a lobbying type of issue where you'd want to start. And in North Carolina, that's Chapter 120C, the lobbying statute. And in that statute contains the definitions for lobbying and a lobbyist, as well as when you need to lobby and when you need to register for lobbying. And in the federal system, you have the Lobbying Disclosure Act and the related amendments that usually come after a variety of scandals. But that's a 2 USC 1601. And that is a different set of rules, but essentially the same purpose of identifying when someone is lobbying, when they need to register for lobbying, and what they do about that. At the federal level, there's a little bit more flexibility in lobbying. You as an attorney or your CEO can make a series of lobbying contacts with a federal official, whether it's in Congress or covered individual in an agency, and not have to register as a lobbyist. Even your outside attorney can do that, or your outside PR firm can do that. I think the problem for in-house counsel and your compliance teams is identifying when you cross the line of not having to register and having to register, because if you cross that line and you don't register, then you're in violation of the LDA, and that triggers potential civil fines as well as criminal prosecution by the Department of Justice. In North Carolina, it's less of a threshold. If you pay your outside PR firm or your outside counsel or anyone, essentially any independent contractor, $1 or more to lobby, then they must register. If you have an internal employee who's doing some lobbying, they do have a little bit more flexibility for not registering. And that's what we call the 30-day 5% rule, where if the employee spends 5% or less of their time in any 30-day period on lobbying, then they don't have to register. In North Carolina, the lobbying jurisdictions are covered by the Secretary of State's Office for Lobbying Registration and the Ethics Commission for essentially lobbyist interaction and behavior with the elected officials and other covered individuals. And I also mentioned that overlapping with lobbying law is campaign finance law, the money that makes all of this work. And of course, a lot of people think money in politics is bad or it's illegal, but of course, it certainly is very much a part of the legal system of the law of campaign finance. And that's all regulated in North Carolina by the Board of Elections, and at the federal level by the Federal Election Commission. Jen, you can go on to the next slide. For in-house counsel, for outside counsel, for your compliance teams, I think this poses a series of challenges. They're manageable, but they're very important, and they're easy to miss if you don't know what you're looking for. You're monitoring for lobbying registration triggers. That is at Raleigh level and at the federal level. When do you register? That's the big one. That's the one where people have gone to jail. Both state lobbyists in Raleigh have gone to jail and for violating that rule, and of course in Washington, where it's a little bit more common to go to jail for violating that rule. So it's important that you assess whether your company has any policy objectives, and you really, as attorneys, need to be engaged in those discussions with your marketing teams or your CEO or whoever is sort of driving the policy side of the business strategy, so that you can help them identify, or at least be on the lookout for potential triggers of when lobbying might occur. Some of you sell products or services to the government, and you may hire outside contractors to help you with that. And you'd also want to include them in your plan for if they are lobbying on behalf of the company. That could create issues as well. And think about this as an example. Your CEO wants to make contributions to politicians. Is that okay? Of course it's okay. It depends on how much and how he does it. CEOs certainly have gotten in trouble for reimbursing employees for making contributions to politicians. That's a big no-no. But at the same time, a CEO may also want to use his political influence and his political contacts to help the business. And is that lobbying? At what point does that become lobbying? So that's a big part, I think, of any compliance plan is communicating with your senior management on what it is that they're doing in terms of their political contributions and their goals. And then what if your CEO wants you or your vice president for marketing to actually start going to fundraising events with politicians? How do you manage that? How does that impact your lobbying compliance plans or your campaign finance plans for that matter? All of those, I think, are issues that are directly driven by the laws that we just mentioned. Can you go to the next slide? Looked a little bit at what the law is and why that's important is because of what's happened in the last year and what's going to happen in 2022. It's been an extraordinary year for politics, obviously with just the presidential election and the changes in Congress. That's been huge. Richard covered a lot of the policy impacts related to tax that we're seeing already. We're not even into the second year of the first of this Congress. And so we've seen a lot of COVID. We've seen a lot of money coming down. I've advised clients that are seeking to either receive COVID relief funds or seeking to do COVID-related contracting for local governments or the state government. And where does lobbying and where does compliance come into all of that? It's a big part of, especially if you're actually selling products or services to the government. It's a big part of your analysis of whether you're going to follow the federal acquisition rules or whether you can follow the federal grant rules. In North Carolina, the biggest deal that we've had this year is the state budget. We haven't had a state budget agreed to by the General Assembly and the governor since 2018. And this year we do. The governor just signed it last month. It's the largest budget we've ever had. It covers a variety of programs, includes various issues, including reductions in corporate income tax. But the big message, I think, with our state budget is that we've got one and that allows at least government to function in a way that it hasn't functioned in the last 2 years. Whether that's good or bad, we'll have to wait and see in 2022. The big change that we'll see next year, of course, is redistricting. The General Assembly has adopted its new districts for the North Carolina House, North Carolina Senate, the U.S. House. And all of that is going to spawn legislation, and further legislation, as well as lawsuits. And it'll be a dynamic that we'll see play out next year through the primary season that'll begin in March, running up to the general election in November. And we just don't know exactly what the districts are going to look like. North Carolina has a new congressional seat. And because of that, that automatically required significant changes in the lines, but how they draw the lines is really going to be subject to lots of litigation that we're going to see over the next 6 months. The North Carolina General Assembly next year will be in short session, which means they start sometime in April probably, and hopefully they'll be out in June or July or August. Although this year, 2021 is the first year in modern history that the General Assembly has been in session for 12 months. So there's no guarantee that we'll see a short session next year, but we might. And if we do, we'll see them focus on the budget and maybe work out another deal with the government. Jenny, next slide. So if you think of government relations and your government lobbying, government relations compliance plan as symbiotic in terms of your business strategy and your legal defense and your legal protections that you want to have through your compliance plans, you can use government relations and compliance plans to really translate the chaos, whether that's the chaos of the legal system or the law behind the regulations, or whether that's the chaos of politics. Whichever way you go, it's going to impact your bottom line. If you're lobbying, you're doing it for a particular business reason, but if you have a compliance plan that is failing, or you don't have a compliance plan and you get punished for that by the media or the regulators or the Department of Justice, it's going to impact your bottom line. It's going to hurt. And then ultimately, of course, you're building relationships with policymakers to help the company, and you've got to balance that with your compliance plan. So I think overall, we have seen this year, and we'll see into next year, companies that have expanded their lobbying plans and their business strategies because of all of this new money that's coming down. Companies that are going to be impacted by these tax changes that Richard covered earlier, and may or may not like them, and might want to change them next year, and they're going to engage. So just be aware of those. Reach out to your compliance team internally, your outside counsel, to make sure that you're following the triggers, that you're doing the registration processes properly. And I think you'll be off to a good start for 2022. Jen, thank you. I will now pass this on to my colleague, Haley Wells, which will wrap it up. And we'll have hopefully some questions at the end. Thank you.
Thank you, Jamie, and thank you for walking us through that explanation on lobbying and providing a glimpse into the legislative crystal ball. Our final rapid fire legal update topic today is going to focus on the topic of ADA accessibility. Specifically, we're going to be talking about Title III of the ADA, which applies to places of public accommodation and commercial facilities. Usually when we hear the term accessibility and think of the ADA, our first thought is the removal of physical barriers. And we're going to touch on those as part of our rapid fire update. But there's another type of ADA accessibility that should be on your radar when it comes to risk management within your organization, and that is website accessibility. While the facts can differ between these types of claims when they present themselves, what is required under the ADA and how we resolve the claims tends to be pretty transferable between the two types of claims. So first, we're going to talk about how the claims present themselves within the organization, what the ADA requires from both the physical access and a website accessibility perspective, and then some risk management tools that you have at your disposal, both proactive and once you're facing a claim from someone outside the organization. So first, how do the claims present themselves within your organization? They tend to come to your attention in one of two ways. The first is you receive a demand letter from an attorney describing the accessibility issue and making some sort of monetary demand on the organization, as well as a demand that you remediate the issue. Second, you have no idea that someone is aware of the issue and you are served with either a federal or a state law complaint that seeks a permanent injunction requiring that the accessibility issue be addressed, and it asserts a claim for attorney's fees. These claims can obviously have a potential negative impact on your organization, both from a reputational standpoint as well as a financial standpoint. And I don't mean to sound too cynical, but in our experience in handling a number of these claims, they tend to be brought by plaintiffs' firms that file hundreds of these claims every year. And their tactic seems to be to, look for businesses or websites that are not strictly compliant with the ADA. That is, they have some sort of technical violation, And they use the same plaintiff to file these types of claims or to assert these demands over and over and over again. And generally their goal is to effectuate some sort of quick monetary settlement. So let's talk first about physical barriers and how these can expose your organization to liability under the ADA. Businesses that are covered under Title III of the ADA must be readily accessible and usable by individuals with disabilities. Often these claims are filed against restaurants, shopping centers, retail businesses, factories, office buildings, doctor's offices, really any kind of place that the public is coming on to the premises of the organization. And they tend to be filed by individuals who have mobility issues, meaning that they use a wheelchair or a walker or have some sort of other physical limitation. They usually involve a plaintiff or a potential customer of the business that is alleging that ramps are too steep or not present, that there's an inadequate number of accessible parking spots or in the parking lot, or the spots that exist are not properly signed, that the slope in the parking lot is too steep, or that there are other physical barriers between the accessible parking areas and the entrance to the business, that the business lacks accessible restrooms, that counter heights are not at the proper height, meaning they're too high or too low, or the doorways are not of a proper width. As you look to how to avoid these claims and prevention of these types of claims, you do have some tools at your disposal. And one suggestion would be, if you're going to enter into a contract to either construct, for new construction, or to make some sort of modifications at your existing facility, then include within your contract with the architect or the general contractor provisions that require these professionals, whether it be the design professional or the GC, to comply with the ADA's regulations on physical accessibility. In addition to requiring that they design and construct your premises in compliance with the guidelines, you should also include an indemnity provision, which would require these professionals to indemnify the organization in the event they fail to meet those design specifications and the organization faces some liability for that. The Department of Justice has issued design standards for ADA compliance, and we would encourage you to incorporate those into your contracts. Now, if you're sitting here thinking, well, I'm glad that I'm a tenant at our facility because clearly this must be something that's the landlord's responsibility, not so fast. Under the ADA, both the tenant and the landlord share responsibility for ensuring that the physical premises is ADA compliant. Now, as between the landlord and the tenant, you can divide or split that responsibility where one party agrees that they'll be responsible for that, particularly if there are going to be modifications or upfit or construction done at the premises. But ultimately, under the ADA, both the landlord and the tenant remain legally responsible for ensuring compliance. So make sure you are aware of that. If you're either you own your premises and you're going to lease out a portion to a tenant, or if you are the tenant and the landlord is the one who is providing the upfit or the design for your premises. Next, we're going to shift gears and talk about websites and how the ADA can expose you to liability with respect to your company website. Under the ADA, websites must be usable and accessible by those with visual impairments, blindness, those who are deaf or hearing impaired, or those who must navigate using a voice, screen reader, or other assistive technology. So generally, if your company website offers products for sale or services that your customers can access through the website, it will be considered an extension of your premises or your physical premises, and therefore it's subject to Title III of the ADA. Courts within a number of jurisdictions have also concluded that a website just standing alone can be a place of public accommodation, independent of any connection with a physical space. And for that reason, oftentimes legal challenges are brought alleging non-compliance with the ADA based on a website in these more permissive jurisdictions. The two states that see the greatest number of these types of claims filed are New York and California. And both of these states allow a potential plaintiff to sue in either federal or state court for ADA violations in connection with a website. So if you sell to customers or you offer services to customers through your website across the country, do be aware that you could face exposure to an ADA claim in one of these far-reaching jurisdictions simply based on non-compliance with the ADA for your website. Unlike physical barriers, under the ADA, there are no clear regulations on what is required for a website to be ADA compliant. That's a little bit frustrating because we don't have a tidy checklist like we do with the ADA regulations for physical accessibility. However, a number of courts and the Department of Justice are quick to rely on the WCAG 2.0 guidelines in evaluating whether or not a website is compliant under the ADA. The Department of Justice takes it one step further, and it's not the WCAG 2.0A requirements, but they actually look to the AA requirements when they are measuring whether or not a website is compliant with the ADA. Now, if you've never heard of WCAG, you're probably not the only person on this webinar. It stands for Website Content Accessibility Guidelines, and it is a set of technical guidelines that outline what is required for a website to be accessible to those who have the types of impairments that I just discussed a few minutes ago. In short, the WCAG 2.0 guidelines have 4 principles that sort of guide whether or not a website is accessible. In short, the website must be perceivable, operable, understandable, and robust. In order to be perceivable, users must be able to perceive the information being presented. That tends to have to, that tends to cover things like contrast on the screen and visual features of the website. The website must be operable, which means that users must be able to operate with the interface using whatever tool they are using to allow them to interact with your website. The content must be understandable, which means that users must be able to understand the information as well as the operation of the user interface. And finally, as I said, it must be robust, meaning that users must be able to access the content as technologies advance. So this is not the type of function where you update your website and then you don't have to worry about it anymore. This is a continuous improvement type obligation where as technologies advance, your website must advance as well so that it continues to be accessible for users. There is now a WCAG 2.1, which requires even greater accessibility and is considered the gold standard by those who want to ensure that their websites are accessible to all users. If you are sitting on this Zoom call and wondering, I wonder how our website stacks up and whether or not we're compliant, there's actually a website you can visit. It's wav.webaim.org. Jen's going to put that in our chat function or Q&A. You go to that website, you type in your organization's website, and it will generate a report which will show you how that particular website complies with each of the WCAG 2.0 requirements. It will flag any deficiencies and can be a great tool for you to audit your website to determine whether or not you're compliant with the ADA. As with the physical accessibility compliance, if you are entering into contracts with web developers who are going to be responsible for designing or maintaining your website, then we recommend that you put the burden on those professionals to make sure that the website is compliant with the WCAG 2.0 guidelines and include that indemnity provision. So finally, we're going to spend just a couple of minutes talking about what do you do if you receive notice of a claim. whether that be a demand letter or a lawsuit. The first thing that you should do is contact your insurance carrier. It may not seem inherently intuitive that this would be the type of claim that is covered by insurance, but we have found that with a number of our clients, they actually did have insurance coverage for these types of claims. So contact your carrier and contact them early so that they don't deny you on the basis that the claim was not timely reported. Second, determine if the issue can be easily remediated. Remediation is a powerful tool when it comes to violations of or alleged violations of access barriers. If the issue can be remediated and the fix is a permanent one or a near permanent one, then that will moot the ADA claim. If you've got a lawsuit pending against you in court, that's great because then you can get the claim dismissed. Now, what will survive is the claim for attorney's fees, because under Title III of the ADA, a plaintiff that brings a claim is entitled to reasonable attorney's fees. And so if you're able to remediate the claim, we recommend remediation, documenting the remediation, and then all that leaves is the negotiation of the attorney's fees portion of the claim. Since these claims, if remediation is possible and accomplished early, since the claims can be resolved early, generally we can resolve them for less than 10 figures because the attorney does not have a lot of time in the case, and it allows you to dispose of the case prior to, and many times, even filing a motion to dismiss or an answer. So if you receive one of these claims, the first step should be put your carrier on notice. Second step, evaluate whether or not you have any sort of remediation options. With that, I'd like to thank everyone for attending today. We hope to be able to join in person at the Umstead next year. And I'm going to turn it back over to Jen, who's going to lead our discussion for the Q&A portion.
Great. Thank you so much, Haley. We did have one question come in while you were giving your presentation, Haley, so I'll go ahead and pose that to you. The question is, if a company serves the public, but the website is just a glorified business card and does give access to services beyond the business contact info, does the company need to think about the ADA for a website? So I think the question is asking, they have a very basic website. It's essentially just a storefront for their business. Are there any considerations that they need to make? Oh, you're muted.
There we go. Thanks, Jen. Okay, so the analysis is really two-pronged. If it's strictly a marketing website and all it does is provide information on, this is the name of our business, these are the types of products and services that we offer, but there's no interaction that can be had through the website, and there are no products or services that can be obtained through the website, then many jurisdictions will say that the website may not be an extension of the physical premises. However, there are at least 3 federal jurisdictions who take a very expansive or permissive view, and will find that even though you can't purchase the product through the website, if it is touting all of the features of the product and or all the features of the services that are offered by the business, then they will find that the website must be accessible under the ADA. So it's really, it's going to be dependent on the jurisdiction that's evaluating it, because, unfortunately at the moment, we don't have any uniformity in how the federal courts are evaluating websites. And so I think, if you're looking at this through the lens of risk management, then you're going to be on much firmer footing if you go ahead and comply with the WCAG 2.0 guidelines in the design of the website.
Great. Thank you so much, Haley. We don't have any other submitted questions, and we are about at time. I want to thank Richard, Chris, Jamie, and Haley for speaking today. For those of you in attendance, we will send an email with a copy of the slide deck and a recording of the session. Warden Smith has submitted sponsor CLE forms to the North Carolina State Bar Board of Continuing Legal Education for pre-approval of general CLE credits for this session. Right now, that approval is still pending, but upon confirmation of program approval, Warden Smith will submit accreditation materials for attendees seeking North Carolina CLE credit only. If you need out-of-state CLE, please email us at rsvp@wardensmith.com, and I'll send you a certificate of attendance as well as the webinar materials for submission. We appreciate you taking your time to join us. This concludes the second session of our virtual in-house counsel seminar.